All right. Well, I want to welcome everyone to the House Judiciary Committee. Today's February 10th, 2022. It's about 2 o'clock. We have a few updates for our agenda today that I'd like to tell everyone because we want to give you an early heads up if your bill is no longer on the calendar. So there was an updated agenda which was provided today. The two bills from the Gunter subcommittee, which was to be at 1:30 today, they've both been continued from today's calendar. House Bill 960 was on the updated agenda, and that will not be heard today. Additionally, House Bill 1088, which was on the agenda, we are not going to hear today. So that leaves House Bill 974, HB 1137, 1271, 1274, and 1275 for the agenda. So anybody have any questions? Has everybody got that? Okay, great. Want to begin by welcoming Judge Charles Barrett from Duluth Municipal Court, my longtime friend and great jurist in our state. It's great to see you, Judge. Thank you for being here today. Yeah. We will go ahead and move on into our first bill, and I've got our, let's see. The first bill I'll call is HB 1137. I see Representative Werkheiser here. If you'd like to come on up, Mr. Chairman, we will get your bill going. All right, that's your pleasure. Go ahead.
Right. Thank you, Chairman. It was not lost on me the volume of bills that are sent to this committee, so I appreciate the grace extended to me to have this bill. A little intimidating presenting to a room full of attorneys, but I was instructed to give the very high level approach to this. On the one hand, it's a very simple bill. It merely removes the exemption that the Department of Corrections has from the APA or the from the current code. There's only about 4 or 5 entities that are protected, and so it removes it. I do have some knowledge of this working with the State Workers' Comp Board, which is another agency that's protected, and we worked on that last year to do an APA light, so to say, but this would remove the exemption that they have. I've done a lot of study on this, and the biggest thing that has interest to me, it is, we have the separation of the executive, the judicial, and the legislative branch. And this merely, to me, that one of the biggest facets is it gives some legislative oversight into the process, and there's a lot of other stuff. With that, I'll stand for questions.
All right. Well, I don't see any questions. I know this has been a real priority of folks contacting my office, reaching out to express support for and request for passage of the bill. We do have some questions now popped up. Representative Dreyer.
Yeah. And I appreciate the intent and the effort to bring this bill. Thanks for doing it. I was just trying to get a little clarity on how will this impact the review of grievances filed by incarcerated individuals?
I talked with the department today about that. It's kind of a mixed answer. It will not remove the privacy protection that inmates and both staff have, sort of like a attorney privilege that exists. So it would not open it wide open, but there would be avenues for judicial review or either legislative review through a process. The APA is very heavy on procedural processes, and so it would have to go through that process.
Okay, I don't understand fully, but I'm going to continue to research. Thank you, Mr. Chair.
Thank you. Representative Leverett.
Thank you, Mr. Chairman. Chairman Werkheiser, thank you for bringing this bill. I think I understand it, but I kind of like Representative Dreyer, I just want to make sure kind of the practical effect of it. Would that be, for example, that you could initiate an administrative review through the Department of Administrative, the administrative courts of a decision, say, on what institution you were assigned to, or whether you had were entitled to certain credits on your time served, because occasionally we get calls, or I get calls from people who want to try to transfer a child who's in a prison in Southwest Georgia to somewhere closer to home, and they're denied that. Would that make that subject to review under the Administrative Procedures Act?
No, you already have that privilege now, and we have for the legislature, Robert Thrower is our contact. In fact, I did that just last week for a stepmom who wanted her child to be transferred. We already have that privilege, and I can get with you with the contact to how to start that process.
Well, I know we can contact someone for help with it, but I wasn't aware you could institute a formal proceeding to have an administrative law judge review that decision. Does that exist currently?
I don't think that would change that, because right now there's already levels of, for example, an inmate cannot be transferred to a different level of security. And so that's the primary. And then there's a secondary. They cannot be within a contiguous county of where their crime was committed. If they reach those two thresholds, they are actually very accommodating in trying to do that.
All right, I don't see any other questions. All right, at this time, I'll hear a motion. So motion to pass from Chairman Oliver. Is there a second? All right, motion to pass and second. Before us is House Bill 1137 is introduced, LC 280421. Any further discussion? Number 8.
Mr. Chairman, I came in late, so I apologize, and I missed the Chairman Workhouse's first introduction of the bill, and I was trying to ask the same question that Representative Leverett was. My assumption is that the Board of Corrections was exempted from, this is the Administrative Procedures Act, right?
Right.
They were exempted from the Administrative Procedures Act for a reason. And we're going to put them back under it. And I was trying to figure out the effect of that. As I understand the Administrative Procedures Act, it's an abuse of discretion standard, as I understand it. And the Administrative Procedures Act allows for review by a superior court judge. Is that correct?
That's correct.
Okay. And so effectively in this list we have before us, there are certain agencies who cannot have their actions reviewed under the Administrative Procedures Act. I don't know that stops you from bringing a case against them in court for any other reasons. If they violate a law, a constitutional question, or things such as that. But we're going to take the Board of Corrections out from under this list that they've been under for a long time. And the effect is now any decision they make, the Board of Corrections, someone can challenge it through the Administrative Procedures Act. I mean, that sounds like what we're doing.
Yeah, but there is a process. As you may or may not know, when through rulemaking, they have to now give the legislature either. So like, I'm more familiar with industry and labor. So if the State Board of Workers' Comp proposes a rule, that has to go to the House Chair and House Senate
Notice. Yes.
and it gives them 30-day review. And then if there's objection, there's got to be a certain number of the sitting members of day 10 of that membership. And then that starts the process. So it's not an automatic, where a citizen can just call up and say, hey, I want to challenge this. So, but there is a process that it goes through that did not previously exist.
Okay, so now, if I may, Mr. Chairman, what I'm trying to understand, I'm very familiar with what the chairman's talking about now. I know the chairman of the Judiciary Committee gets notice
That's
when
correct.
certain agencies do certain things, and therefore in both houses.
Mhm.
And the chairman of both those houses can call a committee meeting, and if a certain amount of committee members vote to do so on both sides, that new administrative rule is postponed from going into effect until the legislative session begins.
That is correct.
And so is your goal the fact that they are exempt from that right now, and we're going to make them come under that? Is that?
That is correct. That process right now, they're exempt from. And so they would be under that, just like Department of Revenue. We had that issue a couple of years ago where the
Right.
Department of Revenue issued a ruling which was different from
Yes.
the intent of the legislature. So
So-
legislature steps in and fixes it.
Mr. Chairman, my mind might have been in the wrong area. When I think of administrative procedure review, I think that if, for example, a Board of Commissioners in a county if they have a zoning matter or some other decision that they make, it can go up to the Superior Court for review and it falls under the Administrative Procedures Act. That's what I was thinking through, the ability to get to court, not how it affected the legislature. I actually like the idea that the Board of Corrections would come to us with their rules and the appropriate committees would be able to review that. Is that the goal here? What about the other side with the judges? I guess is what I'm trying to figure out.
Well, I mean, the very big picture goal is more transparency in the process, because there
Right.
has been, as you know, a lot of discussion. And so it's really just a more transparent process of how the board and the department acts. And so it just gives greater transparency with the agency, and it kind of, I guess, meshes more the silo effect of the executive, legislative, and judicial branch. It kind of brings them together.
Thank you.
All right, Representative Wilson.
Thank you, Mr. Chairman. Apologize for not asking this earlier. What other states are doing this?
As far as I know, only California.
Do you know if that's a recent thing or?
I do not.
I don't see any other questions. We have before us House Bill 1137. There being no further discussion, all those in favor signify by saying aye. Any opposed? All right, it passes unanimously. Thank you, Mr.
sir.
Chairman.
Thank you.
Let's next call. Let's see. Let's call House Bill 1275. If Chairman Rich would like to go and present the bill, and Madam Chair, if you'd like Judge Barrett to come up as well, he's welcome to, if that's what you'd prefer. Would you mind hitting your button, please? Yeah.
All right. Thank you, Mr. Chairman and members of the committee. I am presenting to you today House Bill 1275. I'm working from LC 441896. This is a bill that was requested by the Council of Municipal Court Judges, and I have Judge Barrett here with me today. The council worked with GMA, and they together have worked on the bill, and GMA is supportive of the bill. Municipalities typically contract with lawyers to serve as, or with individuals to serve as their municipal court judges. To better ensure that judges remain, that the city judges remain as impartial as possible, in 2016, the municipal court judges and the municipalities agreed that municipalities could terminate their judges only for cause, and that those judges who are terminated are entitled to due process and to a notice and an explanation. Since that time, there have been a couple of incidents where a city terminated a judge without following due process. So this bill simply updates the code to specifically include the steps of due process that should be there. And I am told that the due process that is outlined in this bill was lifted from the Georgia Fair Dismissal Act, which governs the due process that we afford teachers in our state. At the appropriate time, I just want to make a mention that I do have one amendment to make to the bill that has been requested by the municipal court judges.
Okay,
I didn't want to forget that.
You can go ahead and do that now. if
Okay.
you'd like.
All right, on line 21, we would like to amend to include the following language. Notwithstanding the failure of the governing body of the municipal corporation to provide a contract or enact an ordinance, comma, the minimum term of a municipal court judge shall be 1 year as measured from the date of appointment as reflected in the minutes of the municipal corporation, comma.
Madam Chair, if it would be all right, what would it be possible for you, when you're finished with your testimony, to step back and make a photocopy of the proposed amendment
Yes.
there, and we'll just distribute that to
Okay.
the committee members, and we can
Yes.
do that while Judge Barrett's testifying.
Okay.
If that'd be all right.
Okay.
So
Yeah, that sounds
thank
good.
you so much.
Sure.
Judge Barrett, if you'd like to come forward to the witness seat, we'll hear your testimony. Yes, sir. Right there in the front and center.
Thank you, Mr. Chairman and members of the committee. And on behalf of the Council of Municipal Court Judges of Georgia, I would like to sincerely thank Chairman Rich and the sponsors of the bill, Representative Oliver, Representative Leverett. We have worked on this bill for about 2 years, Mr. Chairman. We've worked very closely with GMA. We've worked very closely with all of our judges to put together what we think is a piece of legislation which addresses these issues. Unfortunately, we have had some cities that have not afforded due process in situations where judges were terminated midterm. They were appointed judges and they were terminated midterm and were not afforded due process. We think that this addresses that. It's I think it's something that the cities can use as a guide in handling these hearings, and we would certainly ask for your support and favorable consideration.
Judge Barrett, has the Municipal Court Judges Council formally considered this proposed legislation and taken any official position on it?
They have, and they do support it officially, Mr. Chairman.
The thinking of potential reasons that a judge could be removed. So maybe with cause, or maybe because there's a political disagreement between members of the city council and
Yes.
the municipal court judge. Can you just talk to us about how this bill will provide protection either from the public, if it's for the public, if there's cause for removal, or maybe insulation of the judicial process from the political implications of a disagreement with the city
So
council?
that is precisely what the statute was intended to do, and it was originally passed in 2016. I think this reinforces that. It gives some protection for the judge from reasons that for political reasons that might exist, disagreements with the city council, mayor, and so forth. And the grounds are set forth in the statute now for removal. And I believe that would certainly protect the integrity of the process, as long as we have that.
Judge Barrett, are you aware of the amendment that's been proposed for today?
I am.
Can you just, if you'd like, I can give you a copy of it.
I have it here, Mr. Chairman.
Can you just maybe talk to us about the reason that the council might be requesting this amendment here today?
Yes, sir. In one of the cases that involves a city in the state that undertook to remove its appointed judge midterm, in their litigation that's pending now, they're taking the position that since there was not a written contract in place with that particular judge, then that judge is serving at will and can be dismissed at any time. What we tried to do with this amendment to the particular section was to address that and say that if the city did not follow the law, if they did not provide a contract, if they did not enact an ordinance, then there would be a minimum term set up via the minutes. It was just to address that, and it did come up fairly recently.
All right, are there any questions for either Chairwoman Rich or Judge Barrett? Mr. Fleming.
Thank you, Mr. Chairman. Judge, thank you for being here today.
Yeah, thank you, sir.
I've worked with the organization before.
Yes,
Good
sir,
folks.
and we appreciate
Trying
it.
to do a
Thank you.
good
Thank you
job.
very much.
As we discussed on the last bill, quite often my mind goes to the practical effect and how this would affect certain situations. And I think I'm clear, and I don't think it would cause a problem what I'm about to ask you, but I thought I would just confirm it. I'm familiar with a city that the council elects the city judge at the first meeting in January every year,
Yes.
which is basically a one-year term, which is very consistent with the amendment as I understand it.
Mhm.
So In that, the charter provides that the city shall elect the municipal judge at the first meeting in January. This whole due process requirements of notice and so forth and so on that I think as I skimmed it, I saw would not be triggered because that judge was basically having a one-year contract and it has to be renewed every January. So none of
Correct.
this in
Correct.
that situation would come into play.
No,
with.
sir. No, sir, we're
Yeah.
not.
If they try to get rid of him after 6 months, they'd have to go through
It
this
would.
procedure.
Precisely.
Okay.
Yes, sir.
You know, they also elect the city attorney, Mr. Chairman, at the same time. Could we put some protections in there for him?
Maybe we can, sir.
All right, number 17, Representative Leverett.
I can answer that question, Chairman Fleming, no, because no one cares about the city attorney. Having been one myself, I know. So if judges, and thank you for taking time out to come down here today. So as I understand it, we're going to sort of by statute impose a minimum one-year term, but if a city wants to have a longer minimum term, they just need to place that in their charter.
Yes, sir, that's correct. And the existing statute, which is in place now, provides for a minimum one-year term for an appointed municipal judge. It can be longer. There are cities that I know of that have a 4-year term. But it's up to the city how they want to handle it.
So are you saying the statute already provides that, or it will provide so after we enact
The
this?
statute already provides for a minimum one-year term for a municipal court judge.
Okay.
Yes, sir.
And I guess this is just clarifying even if they don't specify it when they appoint, it still would apply.
Yes, sir.
Okay.
Yes.
And I understand, I think Chairman Fleming's question is basically if the failure to reappoint for an additional one-year term will not trigger the due process.
No, sir. No, sir. Not at all. And that's a matter for the cities to decide upon themselves. If they want to reappoint a judge, that's fine. If they don't, they don't.
Okay. All right. Thank you, sir. I
Yes,
appreciate it.
sir.
Thank you, Mr. Chairman.
Thank you.
Thank you. Any other questions? All right, I don't see any, so we will hear a motion at this time. Motion to pass. There's motion to pass in a second. All right, the bill is now before us. Chairwoman Rich has proposed an amendment, line 21, to add the language that's been handed out here. Any other discussion about the amendment? I don't think I said it yet, but we are operating off of the bill as introduced, LC 441896.
Yes, sir. Mhm.
Yeah, thank you. If y'all haven't met Brock Perry, our staff attorney, intrepid, keeps us all in line here, makes a great point. I'm going to read out the amendment. So if any of our members are online participating, they can hear it, but it would be to add onto line 21 after the period, notwithstanding the failure of the governing body of the municipal corporation to provide a contract or enact an ordinance, comma, the minimum term of a municipal court judge shall be 1 year as measured from the date of appointment as reflected in the minutes of the municipal corporation, comma, unless the municipal corporation's charter provides for a longer term period. All right, any further questions or discussion about the amendment? Is there a second to the amendment? All right. All in favor of the amendment signify by saying aye.
Aye.
All right. Any opposed? All right. The amendment passes. Bill's now before us. All those in favor of House Bill 1275 as amended signify by saying aye.
Aye.
Any opposed? All right, the bill passes unanimously. It's on to rules. Thank you very much, Judge, for
Thank
being here.
you. Thank you, Mr. Chairman and committee members.
All right, next bill I'll call is House Bill 974, Representative Gullet. All right, and before we get started, this bill came out of the Scoggins subcommittee. So I'll give Chairman Scoggins a minute if he wants to tell us what the recommendation of the subcommittee was.
Thank you, Mr. Chair. The recommendation was due pass on the full committee.
All right, and y'all had 2 hearings on this
Had
bill.
2 hearings on it. Yes.
All right. Very good. Representative Gullet, we'll hear from you. If you would just give us the LC number and present your bill, please.
Thank you, Chairman, members of the committee. LC 500336S is the bill number, and we've had a couple of different substitutes along the way. So this bill would mandate an e-filing of residential documents residential real estate and personal property documents with the clerk. That would include, if you look at lines, that would include lines 20 through 25, deeds, mortgages, liens, maps and plats, state tax executions, and state tax execution renewals. On line 40, any instrument required by to be recorded pursuant to this chapter shall be electronically filed with the clerk of the Superior Court. That's pretty much the teeth of this bill, or what the goal of this bill is. And then there is a front page document that would be, starts at line 66. Starts with the date of the document, names of signatories of the document, goes on through line 79. Those are items that would be on the front page, but there's a reason for this. The clerks have asked for it. The clerk's authority has asked for this. And there are a number of reasons. One is increased access to services by having the opportunity to record documents 24/7, reduce wait times for filers, and locks in the date and time of recording a submission. The electronic tracking of documents is submitted for recording. It streamlines operations of the clerk's office and improves accuracy and accounting for the clerk and the filing party. And also, just to note, there's a free public access terminal in every office of the state. That's already in current law, but we also added it to this bill as well, just to make sure that everyone's clear that there's a terminal for public access at every clerk's office.
All right, thank you. First question is Representative Kelly. All right, so let's try this one. Representative Kelly.
Thank you, Mr. Chairman. Certainly I'm supportive of the idea of this. I think it's a good move forward. I guess my question is what will be, do we expect an increase in the cost to file?
Filing today is free. It's done through the clerk's authority. I think there is a opportunity for software if you do bulk filings that you can subscribe to, and they will help you if you do a ton of these. But for every average day person, and even not that person, they can go file for free at the clerk's office today, or online with the software today.
Just to clear this up, and please, Representative, correct me if I'm wrong, or someone in the room, but this clerk's authority, Georgia Superior Court Clerks Cooperative Authority electronic filing portal, is a state operated electronic filing system. There is no processing fee to file into that system. There are some other privately provided options which do have a convenience fee, but did I get
correct.
that right?
Yes.
All right.
Okay.
All right, we're lit up over here. Let's go to number 7, Representative Walensky. All right, number 4. Not sure if that's Representative Burchett.
Thank you, Mr. Chairman. Thank you, Representative Gullet, for bringing up a bill. I think this will help with efficiency, certainly. And as you know, part of my practice is real estate. And I wanted to bring attention to lines 45 through 49. And can you just give me the impetus for that piece right there? The presence of incorrect tax parcel ID number, absence of tax parcel identification number on record, recorded instrument shall not void or render voidable such instrument.
Yeah, so that's specific, I think, to the just to make sure that if you e-filed it with an incorrect fat key or whatever, it didn't make it incorrect. The actual document itself is what is important that you're filing, not so much what you key you may be on the front page.
All right. So typically when you file one of these, you file with a PT61, and that's where you'd put your tax parcel number. But if you're filing let's just say a deed, that wouldn't have it on it. So what we're saying then is if the PT61 it shows the incorrect tax ID, you're still on notice, about the filing. Is that right?
That's my understanding, but I'm gonna phone a friend at the clerk's office if they want to speak differently.
Thanks, Representative Gullet.
Thank you, Representative Gullet. Thank you, committee. Those lines 45 through 49 are in there because Fulton and DeKalb counties have so many municipalities. They require this information in order to file. The vast majority of counties do not, but we had to put that in there in order to make sure Fulton and DeKalb's municipalities are taken care of. We got to the taxes got to the right municipality. That's the reason for that.
Sir, if you just introduce yourself and tell us where your clerk of court.
Oh, thank you, Mr. Chairman. I'm sorry. I'm Greg Allen. I'm clerk of Superior Court in Forsyth County.
Thank you, Mr. Allen, for being here and all the time you've spent working on this legislation. Representative Evans.
Thank you, Mr. Chairman. I just want to get a little bit of clarity on the fees and make sure I'm understanding. You're saying that right now there's not a fee, but will there be a fee similar to what we pay with Odyssey or Peach to do regular civil court filings?
So as my understanding, there is no fee if you're using the state's portal currently, and that will continue to be the case after the fact, as long as you are using the state's portal, which is available publicly. You do not have to be at the public terminal in the clerk's office to use it.
You can use the state's portal from your office and we're not going to charge for that.
That's correct. Is that correct?
Yes,
Mr.
sir.
Allen?
Yes, sir.
Was in case that changes in the future, was there any discussion of having in the subcommittee, any discussion of having limitations on fees similar to what we have for the civil court case filings?
That was not discussed in subcommittee. Mr. Allen, what would the position be about a limitation?
We don't see a need for the next 5 to 10 years to ever have a fee for real estate filing. Of course, I don't know what will happen in 10 years, but I don't see it happening.
What's distinguishable to me is when e-filing was passed, private providers were contemplated to offer it, and we don't have a private provider here. We have private conveniency options.
That's correct. This would all go through the clerk's authority, and for those bulk filers that have their own special needs, they would be paying that particular private entity a fee to assist them with their filing.
Okay, thank you.
Would you like to follow up on that at all, though? Is that something you want to pursue here today?
No, it sounds like, I hate to say wait and see, but I guess we're watching you. If you guys start charging people, we're going to be coming after you because
we fully understand. Yes, ma'am.
Thank you.
All right. Representative Smith.
Yes. Representative Gullet, I just had a quick question for the clerk's authority online portal that we go through that that Chairman Burchett pointed out earlier to get our PT 61 form. This would be the same online portal that we would use to accomplish your new mandatory online filing, correct?
It's the same portal you're using today. The clerk's authority has today for the e-filing. So I'm not familiar with that form, but if you file it that way today, and most counties already allow you to e-file. Yes, it doesn't change that.
So this is the same medium that we use for the PT 61 form, which will be filing these deeds online.
Yes. Yes, sir.
And my next question is, where does the funding come for that?
The clerk's authority already has funding set up. Well, not funding set up, but the clerk's authority is already accepting e-files from about 140 counties or 150. So this is just kind of making it consistent across the board. The main thing, it does help those that are filing. We don't have two streams of filing now where if you file electronically, you're obviously going to get a quicker and earlier date than if you've mailed it in. Now everything's streamlined. Everything comes electronically. So everybody's going to get their priorities are going to be the same.
Okay, thank you.
Representative Leverett.
Thank you, Mr. Chairman. So I want to clarify because I've done some filing online and I felt at 57 years old, I deserved an award for learning how to do that. So I just want to say that I'm still hurt that no one's congratulating
It's in my
me on
office.
that. Okay, thank you. I'll expect to get that by close of business today.
Perfect. Yes.
But my understanding is there is a fee for filing. You're going to still pay your $25 fee for filing any real estate document, whether you do it online or whether now I can go to the clerk's office and file electronically. I can't just hand the papers across the desk and file it the old fashioned way. analog by giving a clerk pieces of paper. I can't do that anymore. I have to go in, and if I go to the portal in the office, I have to scan them in, create a PDF, and then go through the portal and file, sitting in the clerk's office, just as I would do if I have a computer at my office or at my home. Okay. So it's not free. I mean, I'm still paying for the filing as I should. I acknowledge that. But now in my experience, because as I said, I have done it a few times and always not anticipated that I would file electronically, and I'd collected $25. And when I filed online, I didn't have enough money to pay the fee. There was some additional charge. It was nominal, but there was some additional charge for using that portal, is my understanding. That's my recollection. And again, I'm 57 and I'm prone to remember incorrectly, but that's my recollection. There is a charge for using that portal.
It's not my understanding.
That's on your civil case filings. There is an additional fee. But
Yes,
on
that
real
was
estate,
a
there's not.
steep one. But when I file deeds, there was an additional charge. Now, maybe that's a charge of a third-party vendor, but it's being imposed on me for using that portal.
Ma'am, if you'd like to have a seat right here, well, I'm happy to turn on your microphone and, okay.
Was this through the authorities?
Yes, sir. That's the only way I know to do it.
Was it your credit card company charging you a fee, or?
I don't believe so. I mean, it was shown on that. So I don't want to hold it up. I mean, I think if the clerks want this, it's going to happen, but I don't think it's the case that there is no additional charge for utilizing.
Maybe Chairman Burchett can give us some clarity.
There is a convenience fee. It's like if it's $25, I want to say it's $26.66 or something, and it takes you to a third party processing, credit card processing. So there is a fee. It's a convenience fee, and I've run into the same exact thing. On my closing disclosure, I put $25 for recording. And collected 25, and so you eat the $1.66 or what it is, but there is certainly a fee for convenience, and it takes you to the third party processor. One more, if I may, Mr.
Yes, sir.
Mr. Clerk,
Yes, sir.
thanks again for your testimony. Just want to ask one question. Are all the clerks, I know the answer to this question, but I want to hear it from you. Are all the clerks currently accepting electronic deeds and all these documents currently electronically?
That right now, the clerk has the option, and I believe there's 150 that are. There are some that do not, and this would mandate it for them to do that.
All right, so kind of hitting on what Representative Leverett was saying. So this preempts any in-person filings, correct? So we're saying that from here forward, you cannot file in person at the courthouse.
No, you can still come to the courthouse. We'll have a portal set up for you with a scanner and the PC. The whole station sitting there just like it does for civil cases right now. So you can file at the courthouse. You can file at your office, wherever you may be.
So, okay, that's not the way I understand this. So it says any instrument required to be recorded pursuant to this chapter shall be electronically filed with the clerk of the Superior Court. So that means we're going to be filing in our office through the clerk's authority, or you're saying on site in another, let me see, at a public terminal. Okay.
Yes, sir.
But you can't just go hand it to the clerk anymore and give them a check and here's my $25 and you file it. Is that correct?
That's correct. There are some clerks that will assist you with that if you ask, and some will not. That's kind of a clerk's customer service choice there.
Sure. And then one more follow-up, if I may.
Yes, sir.
Mr. Chairman. Listen, I agree with what we're doing here, so I'm not backing up on this, but those clerks that are not currently doing this, and I'm trying to stay in good graces of my clerk because she's not. Is July 1, 2023 going to be enough time for her to transition to the full electronic recording?
Yes, we are putting a plan in place for the clerk's authority to assist those that are not currently doing this, that are maybe they're a little afraid. They've always done things the old way. but we're putting together a plan to go out and basically visit those counties and personally address it and make sure it's set up and comfortable for them.
Very good. Well, I appreciate that. Thank you.
All right, Chairman Oliver.
I apologize for not being more familiar with what you're trying to accomplish beginning on line 64. This looks like is this a new form? This first page is a new form, and whether or not it's a new form, what information are you now requiring that you did not previously require in items 1 through 9? Or everything that you're listing in 1 through 9 already required in some format?
It's already required, but it does not have to be on the first page. What you have is the clerk's office employees will have to page through the document, maybe to find something. And this makes it hopefully it's going to eliminate mistakes. Everything that's needed in order to record is going to be there on that first page. It won't be rejected.
So the banks are all happy with having to redo their form is what you're telling me.
We reached out to all the stakeholders. We didn't have any concerns with that.
But it is requiring a new format for everybody doing security deeds.
It not necessarily as a form, but that information needs to be included on the first page so it's easily found, and so that when we record it, it's all on that first page. There's not a lot of page flipping and missing pages and such.
And this is really going to be assistance to commercial entities, but if you're a private citizen somehow doing security deeds, you're not going to know anything about this new form.
Well, we hope that by filing electronically, as you know, when you file something electronically, you have to fill in, like say your zip code, your phone number. It won't let you go on. We're hoping to set up that first page so that we capture all that information then, so that it's there and it's not going to be a reason to reject, or we're not going to miss it. They're not going to miss anything.
Thank you.
Representative Kelly.
And so I think that's just kind of what I think a lot of us are bouncing around our head. Some of us do this fairly regularly in our practice. I may file, 20 a year, maybe, and then some of us don't do it at all. So I think we're just trying to figure out the mechanics of how it's working. And so I'm just trying to walk through that. So when I file on Peach Court, I have to put I say me, my paralegal, when they file on Peach Court, they have that first page, we have to get the address and certain things like that for service of process and everything else. And then we scan and upload our complaint and other documents. So is that similar to what this will be, just with the association's website? We'll go on and fill out the basic information. Y'all will generate essentially the form for that, and then I'll scan and upload my deed to be recorded. Is that it?
Yes.
Okay. And I guess just not to fight back and forth about $1.66 on a filing, but is there a way, because we can't mail a check and file electronically, I'm guessing there'd be a way to do a bank draft if we wanted to pursue it that way versus putting it on our credit card to avoid the additional processing fee?
I think yes, we can work on that. Yes.
Okay.
I have not thought of that, but yes, I think we can do for you.
All right. Thank you.
Representative Evans.
Thank you. And sorry for the second question. I had something come in from a constituent who does this a lot. And the point is raised, and tell me if y'all already addressed this in subcommittee, that perhaps more so than people did with even regular civil filings before we went to e-filings, a lot of folks file these property records via mail. And those come in and the clerk just processes them. And I know some of those things can be time sensitive. Is there any plans in place between now and July 1, 2023 to get the word out to those folks that are sending things in by mail, that this change is coming? Or has there been any thought to having a grace period of time where if people are mailing things in, that they're not going to get rejected and have some timing issue triggered?
We did that in my office, and it'll probably be up to the individual clerk, but we sent out, when we had filings come in, when we mailed everything back out, we said effective this date, everything needs to be electronically filed and pointed on our website, and gave them information. So we can do the same. I can work with the authority to do the same for anything that comes through, basically, like, as you said, to get the word out and give everybody notice of what's going to happen.
That sounds great. Thank you.
Representative Leverett.
Thank you, Mr. Chairman. I just had some questions about the line 65 on, which Chairman Oliver touched on, I don't believe line 69 is currently required for a security deed filing, a map and parcel. That's on a PT 61, which you don't have to file with a security deed. So I think that would be a new requirement. And to Chairman Oliver's question, I think if the bank doesn't have a new form, the attorney would just have to prepare a cover sheet with that information. I assume that would be sufficient.
Yes, sir.
Okay.
And line 69 again goes back. We made sure we included the words if applicable, and that addresses Fulton and DeKalb's
Okay,
issues.
all right.
That's
So
the
you
reason
wouldn't
it's
have to
there.
do that unless there's an independent statutory, or the Fulton and Cab requirement statutory?
Yes, sir. They have their own statutory that has to be included. So this,
Okay.
basically, we didn't want to cancel their statute out, but with a new.
I understand. I
new word.
understand. So and I'm assuming, I believe you're correct. All of this information is supposed to be somewhere in the deed. You're just putting it on the front so it's more conveniently located by the clerk to determine if intangible tax is due and make sure the right amount's been remitted.
Exactly.
Okay.
Exactly.
All right, I don't see any other questions. Thank you. If y'all like to just shift over, maybe we can hear from other witnesses. First witness is Mark Robinson.
Mr. Chairman, thank you very much. My name is Mark Robinson. Can you hear me?
Yes, go ahead.
Mark Robinson, and I am currently the vice president of Old Republic Title Company here in Georgia. I'm on the executive committee of the Real Property Law section, and I'm a board member of the Southeast Land Title Association. But I'm not here to represent any of those entities. I'm here on a personal level. I've been an attorney here in the state of Georgia since 1988, basically all real estate practice. And while I appreciate and encourage electronic recording, I do not believe it is in the best interest of the citizens of Georgia to take away the paper filing option. I think as much as we all would like to think that we're all electronically connected and that we all have the ability to do these kind of e-filings, there are citizens in this state that are not. There was a similar issue with the DRR bill a few years ago when they tried to do all electronic searching for their liens. And it was brought up that not everyone has computers and not everyone has the ability to go to the courthouse and file. And in fact, right now, most of the courthouses are closed for COVID. And we don't know that may not happen again. So again, I appreciate the effort of the clerks and I applaud where they're going with this. But I think that from a practice real estate perspective, a common citizen not wanting to go to an attorney, not wanting to have to get the unique ID filing number through the clerk's authority should be able to mail in a deed. Saying that, I think my colleague, Ms. Huskins, is there and she's going to talk more about this some more, I think. And I'd like to say thank you again and see the rest of my time back to the chair.
All right, you have a question, Mr. Robinson.
Yes.
Chairman Fleming.
Thank you, Mr. Chair. Mr. Robinson, which courthouses are closed?
Well, if you go to the clerk authority, a lot of them say that you can't walk in. I mean, it's on the front page of the clerk's websites. I don't know specifically which one it is, but if you go to their notice, there's a notice that some courthouses are closed for COVID. And I think
I wasn't aware of any that's closed right now. That's why I was asking.
That, you know, and we don't know what the future is going to hold. And the mail-in.
I asked that question because my clerk of court, I won't say complaining, but she was discussing with me how even all during COVID, she was open and figuring out a way to do business and everybody always had access. I'm not saying there's not somewhere in Georgia that didn't happen because everybody was trying their best to adjust for a lot of places, but I gave a lot of kudos to the clerks, particularly mine, who I want to stay in the good graces with too, Chairman Barrett, for keeping her office open. So
and I agree. I applaud the clerk's effort as well.
All right, thank you very much, Mr. Robinson.
Thank you,
Those
sir.
are all the questions we have. All right, our next witness we had on the sign-up sheet is Amy Huskins in person. Hi, Ms. Huskins. Yes, if you wouldn't mind just having a seat right up here.
Hi, it's nice to see you again.
You too. Yes, ma'am. Either microphone.
Okay. My name is Amy Huskins, and I've testified before you all before in several occasions. But I'm here today not as a representative of an official portion of the state of Georgia. I'm with Mark. I am a commercial real estate partner at the Atlanta office of Dwayne Morse Law Firm. I've been practicing commercial real estate law for 30 plus years. I do work all over the world, actually, including the state of Georgia. And Mark is correct that several of us in leadership positions of real estate lawyers throughout the state of Georgia have contacted some of us who have been in charge of various things, who are real estate lawyers in the state of Georgia over the past week or so, when we did confirm for sure there's no option for paper filing. And so yesterday, Mark and I actually had a Zoom call with more than 25 lawyers who are quite concerned about the inability after this law is passed to allow paper acceptance of paper original filings, especially for those who are not lawyers. For those people, a grandmother in South Georgia who wants to deed her house to her granddaughter, and that's the only asset she has. And she's elderly and poor and has no car and can't drive to the clerk's office and go hand it to someone to record anymore. That's one example. But I will say that we would like for you to consider an insert to your bill, and the language your legislative counsel can work on, but along the lines of original paper recordations of real estate instruments sent to the clerk by mail, overnight delivery service, and hand delivery service will continue to be accepted, and that the clerk staff will accept original paper filings for recordation if made by walk-in delivery, close quote. And so with that in mind, I wanted to give you one of the main reasons that more than 25 people, including Mark and I, had a conference call throughout the state yesterday. And we've then, all of us 25, have been contacted by many, many dozens of real estate lawyers throughout the state. And this is not going to help us, because if a person who's not a lawyer wants to record a real estate deed or a quitclaim deed or whatever, it's going to be harder to do. The e-filing mechanism is a little bit challenging for someone who doesn't even have a high school degree. It's a little challenging, but more so, we're more concerned about those who do not have the means financially to hire a lawyer or a title company to do this. This is a one-off kind of deal. We're not talking about residential real estate lawyers. Sorry, we're not talking about residential real estate lawyers who have 25 closings a day.
Yeah, sorry about that.
We've, I think someone was accidentally unmuted,
Sure.
so he's
And
muted
so
again.
when this group, we are an informal group at this point. Some of us are in official capacities otherwise, but I'm not speaking today in an official capacity. We were able to reach out to the largest of the title insurance companies based in Washington and their head legislative teams. I mean, I'm talking throughout the country, the people who know about what states do throughout the country, as well as the largest association for title attorneys and title companies in the state, throughout the states. This is nationwide. And if you don't mind, if I could read you what I received last night, because I don't know what has been reported to you in prior meetings, because we weren't informed of your prior meetings or we would have been here. But this came from the head of ALTA last night, and it says there are no states, 0 states, that have formally adopted the policy of prohibiting or forbidding acceptance of paper real estate recordations, period. And I'm going to keep reading what this person wrote. Minnesota was the first state to consider requiring that all counties accept e-recording, but the state's lawyers advised against the idea based on constitutionality provisions. I'm going to keep reading. During the early days of the pandemic, there were a few places, for example, California and Kentucky, where e-recording was the only way to get documents recorded because the courthouses were closed. But as courthouses have reopened, they have all gone back to accepting paper recordings. Wisconsin has just now thought of this as well, and their legal counsel for the legislature said no because of constitutional issues. And so we've been calling around since we received this information about the constitutional provisions to determine exactly what these other states are focusing on. But again, let me just say, and I'll tell you what that is in a second, but let me say 0 other states forbid paper recordings of real estate documents. And so the constitutional provisions, and again, I'm not a constitutional lawyer, but all of us who went to law school know a little bit about it. And those would include a potential restraint against alienation, creation of classes of people, for example, an elderly poor person with no car, who's not a lawyer, who wants to record a one-off instrument, who doesn't have broadband in that swath of that county, which is true in the state of Georgia, even right now. There are some places that don't even have broadband and internet. Fifth Amendment regarding the protection of your right to do what you want with your own property, and then access to courts. Again, I'm not saying this as a constitutional lawyer. I'm saying this so that all of you who are lawyers can consider these concepts. And so again, we are not saying that we agree that every single county in the state of Georgia should be forced to accept e-filings of real estate documents. We do not agree, and we request that you consider this insert to continue to allow paper filings.
Ms. Huskins, what we'll do is ask you to make that copy, that text available to a member of the staff, or if you don't mind, maybe.
I can talk with one of these people over here.
Yeah, or maybe, if maybe our intern or extern could grab it from you, they can make copies of it, return the original to you. I will just say, we notice our committee meetings in the same fashion, and our subcommittee meetings, they're all available online. And we've even we post the notice on the door, and even have put copies of the bills outside the room, anticipating we want to make sure there's plenty of notice. I mean, we do, we really try to go above and beyond to make sure there's notice of our meetings to give folks an opportunity to weigh in. And so I just wanted to clear that up as far as the subcommittee goes. You have a question, Mr. Fleming.
Yes, sir.
Thank you, Mr. Chairman. Counselor, thanks for coming down today. As I listen to your description of the calamities that we're about to cause, I'm reminded of a discussion we had in this very room when we talked about going to electronic filing across the state with pleadings. And there was a lot of concerns that we were really going to be in a calamitous situation. I'm not saying that anybody said the earth was going to end, but there was one senator over there that kind of thought it might. And none of that stuff came to fruition. And as I try to get my head around this, because I'm not a real estate lawyer, I've got a guy in my office that does it, and I depend on him. It seems like what we're limiting really is the mail-in option.
That's right.
It's not so much technically maybe paper, but when you can walk into a clerk's office and scan something in with a piece of paper, I mean, what's the difference between that and handing the piece of paper to the clerk? I mean, you're having to do something. But we're really just talking about the mail. I'm trying to narrow this down. Is that true?
That's correct. And I'm so glad you asked that question, because my group, we discussed that as well. Civil and criminal action pleadings are supposed to be done by lawyers. And so we should know how to file. What we're talking about now are these one-off kind of situations where the general public who are not trained as lawyers, as the example I used, and that we used 5 years ago when we had the situation about the Georgia Department of Revenue. I know y'all remember that. Many of you do remember that. My team worked on that 5 years ago with the AARP, and so there are several other groups, and that log did get rescinded, at least the part that required having a computer and internet access to get this account number for the DOR certification so that you could then file a deed in the state of Georgia. And our research back then, we think, is similar to now, that we're not talking about law firms doing this. We're talking about the general public who might want to do something without having to hire a lawyer to do so.
Let me ask it this way. We actually did have that discussion in this committee about the general public, and it was a pro se plaintiff or anybody without a lawyer who wanted to file a proceeding. And that happens, more than you would think.
That's true.
And we haven't had a response after we did that any of those problems came to fruition. I guarantee you, surely somebody somewhere had trouble filing something, probably just like they had trouble filing something before we ever did stuff electronically. But once again, when you can walk into the clerk's office with your paper and get it filed right there, albeit by using a scanning portal, I'm trying to narrow the
Well,
problem down
thank you.
to just
And
mailing, because I think that's what
I
we're
think
dealing
it's,
with.
we're talking about mail-in is the biggest problem for my team.
Okay.
Because the walk-in, there are some, and I hate to use this example again, but just an elderly, like my mom, she lives in Tennessee, she's 89 years old, she can't drive anymore, she's mentally fine, but if I weren't her daughter and who was a lawyer, and she does have the money, but if she didn't have the money to hire a lawyer, and she wanted to do this, some real estate instrument, she would normally just put it in the mail. And she can't physically go walk in a courthouse to do so. So I think you're right to narrow down this issue. We're asking for a mail-in option. And they would be original real estate instruments, not copies.
All right, Chairman Oliver.
Thank you, Mr. Chairman. I'm just a little surprised that the real estate section of the State Bar has not taken a position on this.
I'm not here in that capacity today.
Am I correct that the State Bar real estate section has not taken a position?
You are correct, because there is a very lengthy process to get approvals, and that has not happened.
Okay, thank you.
That's correct.
All right, Ms. Huskins, thank you very much. And we have, if we haven't already, we'll be handing out this, your proposed amendment, just so
Over
that,
there and give it to someone.
yes, did we not get it already? Did we get it? Oh, yes, we'll get it. I'm sorry. Yeah, if we could get that and make copies. Thank you. All right, we have one more witness who is online, Rob Brandon. Mr. Brandon. All right, go ahead, Mr. Brandon. Mr. Brandon, you are unmuted. Can you hear me? It says talking. All right, Mr. Brandon, going once, going twice. Okay. All right, so I will give the sponsor the last word. Is there anything you would like to say, Representative, as Ms. Huskins' proposed amendments being handed out?
Sorry.
Gotcha.
I think the purpose of the bill is been talked about pretty thoroughly. It is to e-file. It is, there are a lot of safeguards in doing that process, especially during times of COVID. And I think that's what the gist of this bill is about e-filing and making sure that's the process, just from a expediency standpoint, accuracy standpoint, and kind of where we are at this point. So I appreciate y'all hearing the bill.
All right. So at this point, I will hear a motion if there is one. Representative Kelly.
Do pass, Mr. Chairman.
Motion do pass from Representative Kelly. Is there a second? Second from Representative Fleming. All right. Any proposed amendments? All right. I see number 14 is flashing. Representative Smith.
Mr. Chairman, this is just a comment on the bill as a whole.
Yeah, that's fine. Yes. Oh, you can go. We can go ahead and proceed into discussion.
Okay. Thank you, Mr. Chairman. I guess my question is this: what's wrong with just keeping it the way it is? And if you want to pay for the convenience, pay for the convenience. It's worked so far. I don't see how it's not working still. And there are 9 counties in this state of which the clerk doesn't want it. I'm probably going to get shot by mine from bringing up this today, but it's been working pretty good so far. And those that want to use the convenience, they can use the convenience. Why not just keep it the way it is, Mr. Chairman? That would be my question. I know the way the world's turning is more electronic, but it's working good so far. And I mean, unless there's some just all-fire reason that, paper is just absolutely terrible to still use, I think that this process works. If you want to pay for the convenience, that's all well and good. But I think keeping it the way it is, it's worked pretty well so far, Mr. Chair.
Or is there any other discussion about the bill? Representative Fleming.
Good question. Why not just leave it the way it is? That's exactly the question we asked about electronic filing when we voted to go to it for pleadings, a few years back. At that time, there were things that the clerk's office said, or the clerk's authority, and all the clerks came to testify for, is that, having both was a bigger problem than having one or the other. That it was, it is the way of the future. There is change here. There is going to be inconvenience. I am very sympathetic to the description of the person who was old and elderly and had no funds and was not going to be able to make it down to the courthouse. My thought though is that's probably not what's going to keep that person from getting their deed done. They've got a lot of issues to overcome, and us doing this change is not going to prevent that being able to go down to the courthouse. But I would say that it's an efficiency in government issue. That we recognize that when we move to electronic filings, whether it be real estate in this case or pleadings earlier, we eliminated the need for my county, for example, to expand our courthouse because the clerk didn't have enough room for all the records. Now that everything has become electronic, they put off for 10 years expanding the courthouse because she was one of the main people that was going to have it with all the paper records. And as technology gets better and more widespread, it is going to lead to even more efficiencies and savings in government. And once again, there are a lot of legitimate skeptical people when we did this about 3 or 4 years ago with electronic filing. And those were legitimate questions. And I've wondered sometimes, but we haven't seen those problems. At least I have not, that developed. And that is what I hear being repeated now. That's why I feel comfortable going ahead and doing this. And that would be the answer to a very legitimate question.
Chairman Burchett. Chairman Burchett.
I'll be brief, Mr. Chairman. Thank you. So my biggest rub with the legislation is the ability for, let's say, a seasoned attorney to go in and file what he's been filing 50 years right there with the clerk on paper. But that concern is alleviated with the fact that they're required to have a terminal for access for public there. And I suspect that these clerks will help an elderly, grandmother that wants to file a deed that doesn't know how to use a scanner, or whoever doesn't know how to use a scanner. So that's alleviated. I do want to raise one word of caution. We're saying here that they must or shall be filed electronically in the event, Lord help it, that the system goes down. Electricity, whatever it is, the servers. If I have a time-sensitive document to be filed, can you answer what the provision is for that, or what do we do in that case? And then that's all I have to say. Thank you, Mr. Chairman.
I can for the most part. So it's really no different than if the courthouse had a bomb threat and it was evacuated and you couldn't file it. Same type thing. There are reasons why courthouses would be closed today, or you couldn't get to it. A bridge is out. It's really no different from a technological standpoint. If the internet's out, same thing as the bridge is out for whatever reason for you to get to the courthouse. So however you would handle that today would be handled exactly the same way with this.
All right. I thought Representative Smith's light was flashing. He waves. Representative Leverett.
Thank you, Mr. Chairman. I would just like to say, although I know there have not been people protesting in this building based on electronic filing, it has created some issues that do need to be addressed, and that I hope, if this bill passes, would be addressed, such as the inability to predict what I need to collect on a closing statement. It may only be $1.36, but when you add that up at every closing, it starts to it does add up, and it just is an uncertainty that I don't know what I need to collect. Because, on a closing, you've got to disclose that in advance. You have to state what the cost is going to be. And I'm not sure what the formula is for determining what that convenience fee is. So that's something I would hope that the clerk's commission will try to look into, to see if that could either be worked into the $25, or if we could establish some sort of contract with that vendor where they charge a flat rate based on, the number of documents or something of that nature, because that is an inconvenience, and it makes closings almost impossible to do without you having to anticipate coming out of pocket. And that's also, I think, a problem with the other, with the filing of documents in litigation, is if I want to look at copies, I can't go to the clerk and get them and just look at it. I've got to pay for them online, and I don't always know what that cost is going to be. Thank you.
All right. See no further lights flashing for discussion. So at this point, the bill is before us. Any further questions, any amendments? Hearing none. Questions before the committee on the committee substitute as presented here today. This is committee substitute to House Bill 974 LC 500336S.
Are we considering this? That was just handed out to us?
Nobody's requested the amendment at this point. Okay, Chairman Gunter, is you'd like to make what was just handed out inserted after line 53 an amendment?
That is correct.
All right, is there a second to the Gunter amendment? All right, there's a couple seconds. So any discussion of the Gunter amendment? All right, just if we can just hit the high points briefly. We've been over a lot of this. Representative Kelly.
Thank you, Mr. Chairman. I just want to make sure I understand what the true effect would be of the amendment. And in my mind, it's one of the catfish amendments. And instead of attaching an amendment to it at this time, voting on an amendment that I don't think we've had a lot of time to consider, I think instead of just gutting the bill completely, that it would just leave it essentially what we got today. So I would rather us table the measure today before taking up any amendment to give the parties an opportunity to talk and maybe come back before us.
All right, we're still in the discussion phase of the amendment here. Chairman Fleming.
My thoughts were similar to Representative Kelly's, that if we're going to adopt the amendment, you really don't need to adopt the bill, because the bill is either you go to electronic filing or you don't. And this just says you don't. So there's no need to vote yes on the bill. So, and yeah, I think I know what the amendment does, but I would want people to tell me what it does. So I really think we're just back to the original idea that we're going to do it or we're not.
Representative, thank you, sir. Representative Leverett.
Thank you, Mr. Chairman. I suppose ultimately that's for the sponsor of the bill to determine and for every member of this committee to determine, but I think the amendment does nothing about the changes in section 2. Those would still be implemented, and I think the clerks want those. The other provisions about shifting toward electronic filing would still be preserved. Correct. It does change what I think is the sponsor's intent to mandate electronic filing, but it would take sort of a baby step along that way, which I think would be useful. But I think that addresses itself to the judgment of every member.
All right, I'm going to give the last word here to Chairman Burchett, who is the last person to push his button.
Thank you, Mr. Chairman. So this amendment, actually, I think this is sort of splitting the baby here, because what the bill does is mandate acceptance of or electronic documents. What this provision does, which we know that there are some clerks not accepting electronic documents, right? And so those clerks would then be mandated to accept electronic documents, but also still be allowed to use the paper copies. So this is sort of it's in my opinion a compromise here that would take the acceptance of electronic filings while at the same time allowing those folks still the opportunity for the paper filings.
All right. So I'll ask the sponsor, you want to go forward with the amendment right now, or are you asking to table the bill to work on it?
Yeah. Yeah, we'll go forward.
Okay. All right. So so we're in the posture of considering the amendment. And I just said last word to Chairman Burchett. I think we've gone around on the amendment fair amount already. All right. So the amendments before the committee, all those in favor of the Gunter amendment signify by raising your right hand. All right. And for members online, if you are in favor of the Gunter amendment, please say your last name. Okay. And all those opposed, please raise your right hand. And if you are online and opposed, please say your last name.
Holcomb.
All right, the amendment carries. So we're back to the bill as amended. House Bill 974 with the amendment. All those in favor of the committee substitute to House Bill 974 as amended signify by raising your right hand. And if you are in favor, please, and online, please say your last name.
Evans.
All right, Representative Bruce, are you trying to vote?
Yeah, I'm not sure.
Yeah, we can hear you. Are you in favor or opposed?
Yeah. Okay, I'm going to abstain.
Yes, sir. All right. All opposed signify by raising your right hand. Opposed to the bill as amended. All right. If you are opposed and online, please say your last name. All right. The bill as amended, the Judiciary Committee substitute to House Bill 974 passes and is on to rules. All right. Call our next bill now, which will be House Bill 1274. Representative Carson, Chairman Carson, if you would please come forward. All right, let's have order in the court or in the committee room. We have important work to do today. Sal's channeling Judge Scoggins there. So we have important work still on the agenda today. So we'll go ahead and call Chairman Carson's bill, House Bill 1274, to be considered by the committee at this time. And Mr. Chairman, if you would begin by giving us the LC number.
Yes, sir, Mr. Chairman. Thank you very much, members of the committee. I'm working off of House Bill 1274, LC number LC 500323. 500323, correct. So sure, this is basically a bill to codify the definition of anti-Semitism. This definition of anti-Semitism was adopted by the International Holocaust Remembrance Alliance in May of 2016. The IRA's, it's called the IHRA, International Holocaust Remembrance Alliance. Their definition is now the consensus international standard because it can be utilized to objectively assess all ideological forms of anti-Semitism. The IHRA definition is used by the U.S. Departments of Education, Justice, and State. It has also been adopted by the European Union, 34 member countries of the IHRA, and 24 other countries. Support for codifying the definition anti-Semitism is, I would argue, bipartisan. The Federal Anti-Semitism Awareness Act of 2019, Senate Senate 852 in Washington, D.C., passed the Senate unanimously. What this effectively does, as you can see on lines 41 through 62, particularly lines 41 through 43, it provides state officials with an objective definition of contemporary anti-Semitism needed to ensure proper assessment of criminal and discriminatory incidents motivated by anti-Semitism. That's essentially at a high level, Mr. Chairman, what the bill does. I appreciate my friend and colleague, Representative Walensky, and almost near neighbor up here in North Atlanta to help greatly with this legislation, which I think is bipartisan and needed and timely.
And there are a few questions, Mr. Chairman. Representative Walensky.
This will be a long-winded question, but I'll just start out with, wouldn't you agree?
I like it.
At a
I like
time
question like
when dealing with the hostage situation in Texas a couple of weeks ago, to Whoopi Goldberg's most recent statements, to just yesterday in Alabama, a school teacher asked a whole classroom, including Jewish kids, stand up and hail Hitler at the beginning of class as an example. And we're seeing anti-Semitism at a level greater than back before World War II. Any movement to define anti-Semitism and to help people understand and have examples of what anti-Semitism is and is not is incredibly helpful. And this IRA definition is also adopted in various ways by over 20 states in the United States. Wouldn't you agree that this is incredible, critical, important, and also just focuses on and shows that Georgia is incredibly interested in the mutually beneficial relationship between Georgia and Israel and protecting the Jewish people? And one more part to that question is that, isn't it true that this definition right now, anti-Semitism is sometimes difficult to understand and define, and this gives specific examples which removes any overbroadness or understanding of what anti-Semitism is?
I would agree with all those points, Representative Walensky, and the only thing I would add to that is that it's very timely as well, given your examples. I'm sorry.
Representative Kelly.
Thank you, Mr. Chairman. I'm guessing if I Google International Holocaust Remembrance Alliance anti-Semitism definition, I can find it on my phone. Right.
Yes, you can. And I have some examples here printed out from the Department of State, if you like.
My just question was, why didn't we just put the definition into the code section instead of referencing? That's just procedurally I was curious about.
I would defer to Representative Walensky.
Representative Walensky.
Because we're lucky on the House side and in committee in our House, we have incredibly intelligent people, but one may be concerned that people in other chambers may try to change what the IRA definition actually says and mix up those words. So the whole focus through the IRA definition is it's an international definition adopted on the federal level, and we want to keep those specific words intact. We don't want representatives or senators messing with that definition and trying to decide that. And I can get you a copy of all of the hypotheticals that are included in the definition if you need it.
And did Representative Carson, did you say you have that, Chairman Carson?
I do. Yes, sir. This is a late edition, Mr. Chairman.
Yeah, if you'd like to give,
I only have 3 copies.
That's okay. If you'd like to give that one of those copies to Representative Kelly, and he can review it, maybe pass it
Is this
around.
how you do it? I don't know how you do it in Judiciary.
Slide it across the big long table. There you go.
I haven't done that in Ways
like
and
a
Means. I
pro,
apologize.
like you've been here before.
One that way.
Representative Kelly, any
Sorry.
follow up at this time?
I just want you to read the.
Yes, sir. All right, Representative Smith.
Thank you, Mr. Chairman. Chairman Carson, I appreciate you bringing this bill. I'm in full support of it. If you read with me lines 41 through 43, as using this code section term anti-Semitism has the same meaning as provided for in the working definition of anti-Semitism adopted by the International Holocaust Remembrance Alliance on May 26, 2016. Now, I noticed there, Mr. Chairman, it says working definition. And maybe my colleague, Representative Walensky, can comment on this, but am I right or wrong in saying that this is the definition as it was understood on May 26, 2016, or will this continue to be an evolving definition?
Well, you're saying correct, everything you just said. That's why what this is saying is that we will be working off of that specific definition on May 26, 2016. We don't know if the IHRA at any time there was a prior definition, but this is the definition adopted by our federal government and all of the countries and states we listed. So we are specifically saying this working definition that was created on May 26, 2016. And if IRA one day changes it, we're still going to work off this definition for our Georgia code, and a committee or legislature in the future decide to go off a different definition.
Okay, so we just had to change the date of, if we wanted to change it to whatever the federal government made it, we would have to then come back and just change the code section where it says May 26, 2016 to reflect the newer date of the newer definition.
Our current government, federal government right now is using that May 26, 2016 definition. So we are, by stating it this way, applying the same definition. We just don't know if IRA in the future is going to make a change or not.
Okay.
But we don't think they will.
Okay, thank you.
Representative Leverett.
Thank you, Mr. Chairman. I support this bill 100%. I think it's a wonderful bill. I just have the same kind of technical concern about whether we should incorporate the actual definition into the text of the statute or incorporate it by reference a definition that is not set out. As I read it, I'm on the website. The definition itself is 3 lines. It's fairly short. And then there's some examples that to me are great. I mean, it's pretty exhaustive. I appreciate Representative Walensky's concern. I'm willing to support the bill as it is. I feel like I would like that language set out in code so it's clear to someone looking in the code what it is, and they don't have to refer to this other definition. But I guess let me get to my question. The federal law has the same definition worded the same way. It incorporates the IHRA working definition adopted May 26, 2016. That's all it says in the US code.
I believe that's how it's used by the State Department. Let's see, the various departments of the United States government. I don't know if it's been absolutely adopted.
Okay.
By the US government.
All
It
right,
has been adopted by a number of countries and states.
Thank you.
All right. Representative Walensky.
I'll wait for now. We can go.
All right. All right. I don't see any further questions. We do have a few witnesses signed up. The first witness I have online is Kareem El Husseini, I believe. Present, if you'd like to come on up, sir. And please correct me if I mispronounced your name. Okay.
My colleague, Javaria Jamil, was supposed to also testify online, but she's also here.
Yes, sir. Okay. Thank you.
Go ahead.
Yes, sir. Please go ahead. If you would just identify what group you're with and then tell us anything that you want to about the bill.
I appreciate that. Thank you for having me here today, Chair. Good afternoon. My name is Kareem El Husseini. I am the Government Affairs Director with the Georgia chapter of CARE, the Council on American Islamic Relations. We are the nation's largest Muslim civil rights organization. My testimony today is supported by Jewish Voice for Peace, Jewish scholars, and Georgia residents. First, I want to start by saying anti-Semitism is real, but this doesn't do anything to address actual anti-Semitism, a dangerous and insidious ideology, the kind that inspired the massacre at the Tree of Life Synagogue. It doesn't address white supremacy and how that is behind the rising anti-Semitism that we see here today in our country. In the United States, criticizing your government is not only protected speech, but also considered patriotic. I want to repeat that. In a democracy, it is patriotic to criticize your government. If you can't do that, then you don't live in a democracy. Yet under this bill, and with the new definition of anti-Semitism this bill would adopt, we are not allowed to criticize the practices of a foreign government. HB 1274 cites the Irs definition, which wrongly conflates anti-Semitism with criticism of Israel. This bill is asking that the state consider attacks against the country as a hate crime. The state of Israel, which like any other political entity may be judged, opposed, and criticized however harshly. This conflation is harmful. Palestinian solidarity activists have faced racist and Islamophobic harassment for their political beliefs for many years. Human rights advocacy calling for freedom, justice, and equality for Palestinians, or discussions that vigorously criticize Israeli policies are simply not comparable to anti-Jewish hatred, and are in fact based on its opposite, principles of universal human rights and dignity. Amnesty International's new research report, Israel's Apartheid Against Palestinians, a Cruel System of Domination and Crime Against Humanity, which I'm happy to share with all of you, shows that Israeli authorities imposed a system of domination and oppression against the Palestinian people in Israel and the occupied Palestinian territories, and against Palestinian refugees. Laws, policies, and institutional practices all work to expel, fragment, and dispossess Palestinians of their land and property, and deprive Palestinians of their human rights. This treatment amounts to an institutionalized regime of oppression and domination defined as apartheid under international law. Amnesty's research, campaigns, advocacy, and statements pertaining to Israel are focused on the actions of the Israeli government. They are not a condemnation of Judaism or the Jewish people. Yet this bill would declare all of that as anti-Semitic. It's my right and duty as an informed citizen of Georgia, the United States, and as a global citizen to speak out against any country that violates the rights of others, occupies another people, in this case Palestinians, mistreats, discriminates, and performs state violence against Sephardic, Mizrahi, Ethiopian Jews, and African asylum seekers, and forcibly deports them to countries where their safety is not guaranteed, endangering their lives even more. Saying these things has nothing to do with being anti-Semitic. It has everything to do with being a good global citizen and thinking about human rights for everyone. This bill ultimately undermines civil liberties while failing to address real bigotry. And whether you agree with my testimony today or not, I'm asking you today to not restrict my freedom of speech by passing this bill. Thank you.
All right. There's a question. Representative Walensky.
I don't think that this definition, everything you just said, would be definitely under freedom of speech, and I don't believe anti-Semitism based on this definition. Can you point to where in the examples or code any
Yes.
where you say your thoughts about the Israeli government's decisions would fall under anti-Semitism?
Let me give you.
That's fine. Would you just identify your, I tell you what, would you mind coming over here to a microphone so everybody has a microphone and just introduce yourself to the committee?
Thank you for this opportunity. Is it turned on?
Yes.
Okay,
we got
great.
you now.
My name is Javeria Jamil, and I'm the Legal and Policy Director at CARE Georgia. I will address your question, actually. So under the many examples of what constitutes as anti-Semitism under the Irs definition, one of the examples is calling the state of Israel a racist endeavor, right?
We can agree he didn't just do that, right?
I'm not going to comment on that. I'm just going to comment on why that's actually protected first speech under the US Constitution. And this definition is saying that we can say that.
Thank you, ma'am. What we'll do is go around for any other questions for the two witnesses who are at the microphones right now. Representative.
I'm sorry, Chairman. If you don't mind, I do have testimony of my own that I would like to.
Okay. Is there anybody else in the room who's here to testify on this bill? All right. You are the only addition then in the room, so that's fine. I'll allow your testimony, but we have a few questions before we get to you. Okay. All right. Representative Fleming.
Thank you, Mr. Chairman. On line 50 of the bill, it begins by saying nothing in this code section shall be construed to diminish or infringe upon any protected under the first, any right protected under the First Amendment to the United States or the Georgia Constitution, which is, of course, is free speech laws. Why does that not solve your problem?
Because claiming that the state of Israel is being racist in its endeavor of apartheid against the Palestinian people flies in the direct, like, I mean, that's what the section, what the bill says. It says you can't call Israel a racist endeavor, but apartheid is racist.
All right, ma'am, if you would like to, if it's all right, sir, maybe I see your colleague is here at the microphone again. That's all the questions that we have for you. We'll just allow her to go ahead and give her testimony as an add-on witness here today as she's requested. And you can just return back to the gallery here. And ma'am, if you would just begin again with your title and your name and the organization you're with, and then we'll hear any testimony that you may have for us. Go ahead.
Thank you so much. So good afternoon, everybody. Again, my name is Javeria Jamil, and I am the Legal and Policy Director at CARE Georgia. And I'm here today, just like my colleague, to express my opposition to this bill. So this bill requires the state of Georgia to adopt the Irs redefinition of anti-Semitism, which is problematic for several reasons, some of which you've heard from my colleague, but some of which I just want to highlight for you. So first, the IRE definition of anti-Semitism is actually vague, right? So for example, it redefines anti-Semitism as a certain perception of Jews, and that's in quotes. It's unclear what that means. Second, and most importantly, and that's the point here, it broadens the definition of anti-Semitism to include criticisms of Israel and Zionism, thereby chilling free speech and stifling legitimate political discourse. Kenneth Stern, the original author of the IRE redefinition, has argued against its adoption because of its impact on First Amendment protected activity. The examples and explanation in the IRE redefinition, as I spoke about, right, are also run afoul of First Amendment protections and actually have been used to stifle free speech across the country already. So Zionist activists have attempted to cancel otherwise protected First Amendment events, protests, speeches, and university lectures based on this redefinition. Just recently, Fordham University in New Jersey refused to allow the formation of a student group advocating for justice for Palestinians based in part on the redefinition of anti-Semitism that's been, introduced by IRA. That's stifling student political activism and speech. So there's that example of how does it, go against our First Amendment activities. Even if those activities are protected, what happens as a reality every day for activists who are speaking up for justice and peace in Palestine is that their activities are often stifled, they're often attacked, complaints are lodged against them with the federal government, with other authorities, and they're more and more not able to do what they should be allowed to do under the First Amendment. So it has a chilling effect. And I also want to say, it's probably no coincidence, right, that this bill comes now, only a few weeks after the Amnesty International report came out, labeling Israel as an apartheid state, giving credence to what Palestinian activists for Palestinian rights have been saying for decades. And finally, and quite frankly, the redefinition is dangerous. By encompassing phenomena that are clearly not anti-Jewish, it can only make it more difficult to recognize, isolate, and oppose actual anti-Semitic hatred when it really does appear. Just yesterday, Deborah Lipstadt, a professor at Emory University and the US government's pick as the federal government's anti-Semitism envoy, cautioned against conflating anti-Semitism with criticisms of Israel and Zionism during her Senate confirmation hearing. She specifically said, if you call everything anti-Semitism, when you have a real act of anti-Semitism, people aren't paying attention. And so for these reasons, I'm asking that this committee vote no on this bill. Thank you.
Ma'am, you have one question, Representative Smith.
Yes, thank you all for being here today. And I just want to preface this. When I was in college, I went to college with individuals from all over the world, both Jew, Gentile, Muslim, and Buddhist. And so I empathize. I have friends that believe quite differently than I do on this. But you mentioned the Amnesty International 280-page plus report that was filed. And even though I think this is more of an international conversation, and believe it or not, somebody from Harrison County does look into international events. But it was curious this come up today because I was just listening to some information on this very topic. And I think if you look at that 280 plus page report by Amnesty International, and you can correct me if I'm wrong, but it's clear that they say that Israel didn't become an apartheid state by some declared human rights abuses over the course of the last several decades. I believe it references that Israel, in their opinion, has been an apartheid state ever since they were formed in 1948. And so I think that has no bearing on this committee's decision here today.
All right.
Is that a question that's posed to me, or
Don't
is it a
believe it
comment?
was. but
Okay, all right.
Thank you. All right. So we have two more. Now I see some lights flashing. Are you, we have two more witnesses. Would you like to hold your comment until we hear from those witnesses? All right. We have two witnesses who are signed up online. David Goldman. Mr. Goldman, if you would unmute and go ahead and proceed with your testimony.
For sure. Thank you so much. Good afternoon, Chairman and members of the committee. My name is David Goldman. and I am the Policy Counsel for the American Civil Liberties Union of Georgia. Today, I'd like to share the ACLU of Georgia's grave concerns about HB 1274 as currently drafted. Our primary concern with HB 1274 is that this bill would prohibit constitutionally protected speech and risk criminalizing the expression of criticism of the government of Israel. The International Holocaust Remembrance Alliance's definition adopted by this bill is overly broad. While the definition goes to some lengths to exclude criticism of Israel, the line between criticism of Israel and discriminatory animus remains too blurred to function as a law that ultimately punishes people for their speech. One such note in the IHRA's definition is that criticism of Israel, similar to that level against any other country, cannot be regarded as anti-Semitic. This language is unclear and unenforceable. The state of Georgia is not a ministry of information that decides whether certain criticism of Israel is similar to that level against any other country. For example, as a Jewish American who is frequently critical of recent Israeli administrations, I wonder whether my speech could be construed to run afoul of these restrictions. Or more likely, would a non-Jewish person making the exact same criticisms as me be considered anti-Semitic while I am not? That is the determination we are leaving to the state of Georgia to make, and that is problematic. This definition remains useful as a moral or sociological definition, but not as a legal one. Even the Office of the United Nations High Commissioner for Human Rights, which has adopted the IHRA's language as a working definition, has clearly stated that this definition is a non-legally binding definition intended to guide and educate. It is not a means to squelch debate or free speech, and those who misuse it this way should be opposed. The ACLU of Georgia also believes that this legislation is unnecessary. Importantly, Jewish Georgians are already protected by the Georgia Code and the Civil Rights Act of 1964, under which numerous courts have held that Jews, whether actively religious or not, are protected from discrimination under the race and national origin language. Ultimately, HB 1274 would have a chilling effect on constitutionally protected free speech. This committee should not pass this legislation as drafted. And at the very least, this committee must reconsider incorporating the IHRA's definition of anti-Semitism into Georgia law. Thank you.
Mr. Goldman, you have a question. Representative Walensky.
Hey, Mr. Goldman. Quick question. Just, I guess you're speaking on behalf of the ACLU today, but was there severe concerns about how the ACLU, how the hate crimes bill would be used by prosecutors throughout Georgia? It's just concerning to me that we have the hate crimes bill adopted, which could be used in any way. And it looks like here we're trying to define anti-Semitism for the clear reasons I said before. But now there's concerns on how it would be used when the adoption of the hate crimes bill was adopted without those concerns.
Yeah, I am not aware of a particular instance where Jewish Georgians have not been covered under a certain incidents. We don't want there to be a gap or a loophole, and if this committee is able to identify that, we are happy to work with the bill drafters on the language. But yes.
All right, Mr. Goldman, there's a question from Representative Leverett.
Good afternoon, Mr. Goldman. Thank you for your testimony. I wondered, does the ACLU is the ACLU aware of a working definition it would feel would be sufficient for legal purposes?
As regards to language that would be acceptable to this bill, we're happy to take that offline and chat with the sponsors.
One other question, Mr. Chairman, if I may.
Yes, sir.
As I interpret this definition, there is about a 3-line broad definition of anti-Semitism, and then there are some contemporary examples, which actually, to me, serve as additional, more definite definitions of anti-Semitic acts. I wondered again, and maybe this is a discussion we can have offline, and I'd be interested in hearing the other witnesses' view of this. Are there a lot of the bullet points in that definition have nothing to do with Israel as a state? They have to do with singling out a Jewish person for some kind of persecution or violence simply because they're Jewish or because they are associated with Israel as a state. And the comment would be based on some perception that there is this association by virtue of their ethnicity or their religion with Israeli policy.
Yeah.
And so I guess what I would like to pose is, are there certain provisions in that definition that could be stricken to resolve the concerns the ACLU has, at least satisfactorily, while retaining some of the other provisions that seem to me to be completely non-objectionable from any perspective?
That is definitely a discussion to be had. I think there are, the two parts of it. There's the definition itself, which is very vague, and especially a certain perception of Jews. And then there are parts that we have concerns with in the incorporated examples. I would agree that some of those examples themselves aren't necessarily controversial, while others are. But I think this goes back to the larger point that this is a working definition. And in this bill and through comments during this hearing, it was mentioned that so many different entities have adopted this. Well, not all those entities have adopted it as law being incorporated into code, but rather as an illustrative guide. And I think that is something we want to put out there, that yes, this can be educational, this could be helpful, but we think being incorporated into Georgia law is very problematic, especially when there are criminal penalties and prohibitions at place that could affect people just expressing their constitutionally protected free speech.
So I want to follow up.
Yes,
so
go
I
ahead.
understand your response to that question, as lengthy as I admit it was. No, you do not feel like there are provisions of this, the examples in the definition that could be isolated within a definition that would stand constitutional and due process muster.
Well, that's something we should chat about. But there are definitely problematic aspects of these examples here.
I understand, and I'm suggesting there's some things that could be stricken, I think, to address the concerns that have been addressed today while still preserving the essence of the bill.
Yeah.
I don't know if the sponsor would want to do that, or if it will be necessary to do that. I'm just trying to have a conversation to see what
we will
the specific sort of texture of your objection.
Yes, well, we are 100% open to having that conversation about specific examples. If it would make the bill more palatable, we can go ahead and talk about that.
All right, thank you so much. Thank you.
All right, no further questions for you, Mr. Goldman. Thank you. Next witness we have is Joe Sabag. And sir, if you would just introduce yourself, please correct me if I mispronounced your name, and go ahead and proceed with your testimony.
Mr. Chairman, my name is Joseph Sabag. I'm here on behalf of the Jewish community and the Israeli American Council. Unless there are any specific questions that I can help to clarify, I'm happy to go ahead and waive comment.
Do you express support for the legislation?
Certainly, on behalf of Jewish victims of anti-Semitism, we feel that this is a very important piece of legislation that will help make certain there are equal protections for Jewish persons under the law. Our community definitely needs protection from crime and discrimination at this point. I have also, just by way of reference, served as an expert in South Carolina and Florida's adoption of similar definitions prior to consensus having been established around the IHRA definition. So again, with that being said, I'll waive comment unless there are any specific questions that I can be helpful with.
All right, there are no questions. Thank you very much, sir. All right, the bill is now before the committee. Is there a motion? Motion to pass from Representative Fleming, second from Representative Walensky. Any discussion, amendments? Hearing none. All those in favor signify by saying aye.
Aye.
All those opposed signify by saying no. All right, the bill passes unanimously. It's on to rules. Thank you very much. Thank you. All right, the next bill that we have is our final bill on the agenda. House Bill 1271, Chairman Burchett, if you, okay. Yeah, if you'd like to go ahead and. All right, let's go ahead and pass out the substitute, make sure everyone has that before we get started with this bill. All right, very good. So we will go ahead and hear from Chairman Burchett at this time. If you would just give us the LC number of the bill and proceed with your presentation.
Thank you, Mr. Chairman. Thank you, committee, for hearing this bill. This is House Bill 1271, and the LC I'm reading from is LC 480542S. Is that the one that just came out? All right. So this bill is a very straightforward bill. It's codification of a federal law, something that I didn't know was not already codified into law. I had a constituent come to me from back home and said that his HOA was not allowing him to display the American flag. And I didn't realize it at the time, but this did not have any state law that allows or doesn't or prohibits an HOA from doing such a thing. But in my research, I found that there is federal law that says that the flag shall not be prohibited from being flown by an HOA or property condominium association, etc. So what I've done here is essentially codified that into state law, so that a person in Valdosta would have redress within the superior courts, just like they would be in the federal court. And in pertinent part, and really the gut of the bill, and I'm going to have to ask that when it comes time for amendments, for one amendment to strike a provision, but this basically says that a homeowners association, what we define as a property owners association in our code, which encompasses a HOA or a condominium association or any of the like, cannot prevent a person from flying the American flag. Now, within this, there is within reason, and there's a case law to back this up, that if it's a substantial interest of like public safety, for instance, if someone wants to fly a 50-foot flag at a corner of an intersection, then it impedes the vision of the roadway, then they can make restrictions on that. So this is within reason, is what the case law says on this. And in the version that you have, I have a size in here, but having reflected on the size, I think I want to strike the size out of there. So the language would essentially read prohibit on lines 23, prohibit a lot owner or a person with a right to exclusive possession from displaying the official flag of the United States, period. Strike through the use of an attachment to the structure, and strike provide, or strike all of line 25, and strike all of up to the period in line 26, 6 feet. That's the crux of the bill. I'll stand for questions and do my best to answer any questions.
Chairman, with that proposed amendment, can you just direct us to where the discretion would be given in circumstances at the intersection example you just gave?
I did it. So the reason I wanted to strike the size parameter is because I didn't want it to be, and I'm going to answer your question, Mr. Chairman. I didn't want it to be interpreted in a way that this is the only size that could be flown, right? If they want to allow them to fly larger flags, I want to allow them to fly larger flags. We did not cite to the official flag code or to the federal code itself. There's limiting language within that official code, and if you think it's best that we cite to that, I'm certainly open to doing that.
All right, Representative Wilson.
I wonder if, first of all, and as the chairman was calling this bill up, I shared with you, Chairman Burchett, that I like this bill. I wonder if your amendment, though, doesn't also allow for the opposite effect. Couldn't an HOA just say, okay, you can display the flag so long as it's no larger than 2 inches by 1 inch? And that would be in compliance with this, the way it's written here.
Well, that's certainly the reason we have that language in there. But in having conversations, and again, I'm open to the will of the committee here. I didn't want to limit, I don't want it to be interpreted in such a way that only a 4.5 feet by 6 foot flag can fly. So like I said, I'm open to your interpretation, but it certainly could be read that way. You could say we're allowing you to display the flag, and they could say you can only have a 1 foot flag on your property, or no higher than 3 foot.
All right. Any other questions, Representative Wilson? Representative Fleming.
Thank you, Chairman. Representative Brissett, I was just going to bring your attention to line 35 on the bill. I didn't know if you wanted to make an amendment there too.
That's what I would, but Representative, if I would really like your input on the bill there. What are your thoughts about that amendment if I were to propose it?
Well, I guess my thought is the situation you have right now is that you have associations not allowing people to fly flags, and that's really the goal, to stop that. So once we pass something that says you can't stop someone from flying a flag, then the fear would be, well, they'll try to get around that a little bit by saying how large the flag can be. So I guess my initial thought was, if you just go with your initial thought, just taking the amendment off, let's see how they react when we do this, and if we need to come back and change it later, we can, because the deeper you get into those details, maybe the more harder it is to decide how to handle it.
Right, and I suspect if someone were to bring a piece of litigation, HOA doesn't allow you to fly your flag, you file suit in superior court. The jurisprudence they're going to be looking at is federal law, and they're going to find that they have the right for a substantial interest to allow the time, place, and manner of how the flag's flown. So if there's no substantial interest, and it's a 10-foot flag, and it's not in the way of the property owners association, then it should be suitable, I would think.
All right, Representative Smith.
Yes, thank you, Mr. Chairman. The only caution I would throw out there, Chairman Burchett, about the flag code, and I was thinking this was right just from having been raised by a Marine combat veteran. If you display a flag overnight, you have to make sure that it is properly illuminated. Now, I mean, the customs to display it from sunrise to sunset on buildings and on stationary flag staffs and open. The only issue I see here is some smarty pants on the HOA board may read that code section there for the federal flag code and may run afoul of that. Now, I do think proper etiquette should be followed on that. That's just my only caution there.
I agree. That was part of the reason we didn't cite to the flag code itself, because also, if it's raining and wet, there's a protocol for flying the flag. And if it were they're to be flown at half staff, and the homeowner doesn't know that, I mean, I don't want someone going after the homeowner for something like that.
All right. Representative Gunter.
Thank you, Mr. Chairman. Representative Burchett, would a definition of like a flag of reasonable size, that kind of language, cover what you're talking about?
I'm certainly open to that, Chairman Gunter, but I wanted to stay away from the size in particular, so that there was nothing more read into the federal code than was already there in the state code.
Thank you.
Representative Leverett.
Thank you, Mr. Chairman. Chairman Burchett, I think this is a great bill. I wasn't aware this was an issue either. So I think it's great that we put this into state law. I'll not to indicate my complete submissiveness and pliability, but I'll vote it out however you want it. But I kind of like keeping the maximum or minimum sizing, because it basically says they can't regulate anything that size or smaller. So it would ensure that they could display it, and sort of, I guess, to Representative Wilson's point. I feel like otherwise you're saying, well, they're fine. Okay, you can put up a flag this big, so we're complying with the statute. But I will I haven't read the federal code and not aware of how it might intersect with a state law that addresses the same issue. So I'll defer to your wisdom on that. Will.
I'm fine with that. I'm fine with your suggestion of leaving the 4 1/2 foot by 6 feet. Maybe just striking the structure to the building, because if they want to fly it on flagpole, I want to allow them to do that. But the flagpole, I think is going to be the sort of the structure that's going to be, the structure that they're going to want to argue about. The HOAs is if whether or not the flagpole is in the right of way. If it's 50 feet in a neighborhood, nobody wants that. So, but I will say that that would be a sufficient interest for them to regulate time, place, and manner. A 50-foot flagpole in a neighborhood that could fall down across and hit your neighbor's house or across the road, et cetera.
I concur with the comments about not seeing a need for an amendment at this time with what's been presented here in this substitute, but of course we'll do whatever the committee wants to here. So I will proceed now with, do I hear a motion on the substitute to House Bill 1271? All right, there's a motion and a second. This is LC 480542S. Any amendments? Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? All right, passes unanimously on to rules. So for
Thank you,
all of
sir.
our sponsors today, if you would please either meet me in the Judiciary office now so I can go ahead and sign your rules committee form so you're not looking for me later. And I want to note today for a period, we had perfect attendance from our permanent members on the Judiciary Committee. I don't know if I've ever seen that before. It was and so I want to commend the members of this committee. I know we work very hard. We work very hard around here, and I want to thank everybody for making time here today. We're adjourned.